Hi, how are you? This is Eric Rodebois from EPGD Business Law, doing business as EPGD. Wait, no, it is EPGD Business Law. EPGD Attorneys at Law PA, doing business as EPGD Business Law. And today I want to talk to you guys about something really interesting. It comes up in a lot of contexts. And this is the residential constructive eviction. So let's talk real quick about what we're talking about. So residential as opposed to commercial. Now, funny thing is, if you look at the statute here in Florida for residential, if you stacked it all up on paper, it would be about that thick. If you stacked up the one for commercial tenancies, it would be about that thick. And the difference is because in commercial context, they assume it's business people negotiating arm's length and that they'll do everything they want in the lease. Whereas in residential, they don't assume that you're dealing with as many sophisticated parties, and so there are more protections for the tenant. So whether you're doing this on a handshake or whether you're doing this with a nice written lease, which if you're a landlord out there, please have a nice written lease. The main difference being you'll get attorney's fees if there's disputes because you'll have an attorney's fee clause, among many other things. And so what we have is the implied covenant of quiet enjoyment and the implied warranty of habitability. Now, these two things, whether it says it in the lease, the handshake lease or the 30-page lease, are in there, no matter what. And so what they say is that a landlord has a duty, in a sense, to provide to the tenant a safe place to live. And so where this comes up is when we have what's called a constructive eviction. Now let's look at the word eviction for a second. Eviction means that the landlord is going to force the tenant to get out. And so typically that will happen where the tenant's not paying rent. There could be other circumstances where they're breaching the lease. Let's say that they keep having crazy parties and maybe there's a clause in the lease that says that they can't do that, whatever. So they'll have a court process. It's called the eviction. You'll hire a lawyer, you go to court, it's usually a drawn out thing. Because the law is so protective of the tenants. So one of these protections, the one we're talking about today, is that the landlord has to make sure that the place is habitable. So, for example, if there's a big pipe leak and there's water everywhere, maybe the place is no longer habitable. Maybe the one bathroom no longer operates, or worse. Maybe the kitchen doesn't work. And so how about this? Is air conditioning a requirement? And this has actually been evolving over the years because, air conditioning is a relatively new invention, but we've evolved as a society to a point where, if there's air conditioning, the landlord might be required to maintain it. Now, let me be clear. This is a state-by-state, jurisdiction by jurisdiction question, so your state might have slightly different rules. And also, we're looking at local codes for like your own city. And then also, you want to look at the lease. So let's walk through the steps of a constructive eviction. Let's say that there's some sort of defect in the property that renders the property uninhabitable. And now it's a facts and circumstances test, and I'll get to that story in a second. So the tenant at that moment can stop paying rent and then has to give a notice immediately, or within a reasonable amount of time. They can't just sit on it and not pay their rent but never tell the landlord. They have to give notice to the landlord, usually has to be in writing, and they'll have to tell the landlord, hey, here's what's wrong. The bathroom's broken. There's a big leak. You need to fix it. Okay. Then they have to give the landlord a reasonable amount of time to fix it, and in Florida, it's in the statute. They have 20 days. So if the landlord goes and fixes the problem, then the tenant has to pay the rent that they owed anyways, and then everything's back to normal. Now, let's say that the landlord does not fix the problem within 20 days. Then the tenant can continue to not pay rent. They can then move out, break the lease, and be off the hook for everything. And frankly, they'll probably be entitled to get their security deposit back. Now, you can see why this would cause a lot of problems. So this is a story that happened the other day. One of my clients is actually the landlord. And so the landlord, they had a written lease for a luxury condo that he's renting out in a high-rise in Miami with a view as far as you can see over the water. And there was a 3-inch crack in the sliding glass door. Okay? 3-inch crack. Not a shattered window, not rendering the place so that the air conditioning wasn't working and they were sweltering in 110 degrees. It was a little crack in the door. And so the tenant hasn't paid rent for 3 months. And now, to the tenant's credit, the tenant has certainly told the landlord, hey, you need to fix this crack. But I'm willing to bet that if we took this all the way to court, a judge would not agree that having a 3-inch crack in your luxury $5,000 a month condo, even though that's unfortunate and maybe you can't have your fancy dinner parties, the 3-inch crack that's in no other way affecting the structural integrity of the apartment is probably not a substantial eviction, right? So going back to what constructive eviction means, it means that because the situation in the either apartment or home that you're renting has become so bad that it's almost as though the landlord is forcing you to get out. So again, the leak or the broken plumbing or something. Probably not the 3-inch crack in the window. So remember, substantial problem, you got to give notice, 20 days opportunity to cure, you don't have to pay rent, and then you can get out and be released from your lease. So if you're a landlord, you need to take this seriously. If you're a tenant, you need to know about the notice requirement, because if you don't give notice, then you'll be in breach by not paying your rent. So for everyone who has any questions about residential tenancies and constructive eviction, give me a call. I'm Eric Rodebois, EPGD Business Law.